The Supreme Court of Ohio considered several important legal issues when it conducted oral arguments in June. The court heard 16 cases, including one from Geauga County, addressing a woman's objections to her probation terms. Susan Baelish pleaded guilty to misdemeanor theft for stealing from a store. The judge allowed her to avoid time in jail, but placed her on 1 year of active reporting probation. The judge imposed several conditions, including no consumption of alcohol or going into a bar unless it was for work. Baelish objected to the drug and alcohol restrictions, arguing they were not related to her crime of theft. The judge stated Baelish came before the same court recently for drug and alcohol-related crimes. The judge insisted on the alcohol restrictions. An appeals court agreed with Baelish's objections and overturned her sentence. The Geauga County Prosecutor's Office argues to the Supreme Court that the law allows the judge to impose the alcohol restrictions, even if not related to the theft.
What if a condition has nothing to do with this offender or the crime or any rehabilitation? Well, it just seems, purely someone has no history of an alcohol or drug problem and you're ordering drug testing.
Here, I would agree. I think if the court is authorized to impose no drugs or alcohol, there is no requirement that the court show there be a connection. I think there is a relationship to rehabilitation because it's about punishment and deterrence. And so it would send a message to that person that, hey, if you commit a crime, even if you've got no history of drugs or alcohol weren't related to the offense, there's going to be a punishment for committing a crime, and that will make the person think about future crime.
The justices questioned how broad is a trial judge's discretion to impose conditions.
You want the court to be hamstrung and not give them the treatment they need and simply sentence them on the crime that they're in front of the court on.
If the crime truly has no nexus to drug or alcohol conditions and the court just knows about it, there would be some other condition that would help the defendant but would not be totally arbitrary to the crime that was committed. But if the crime has no nexus, we would argue that's an abuse of discretion.
In his second case, DeMarco Gowdy got into a fight at a fast food parking lot in Cincinnati. Gowdy pulled out a gun and shot the other man, injuring him. Gowdy was charged with felonious assault and faced up to 20 years in prison. At a pretrial hearing, the trial judge watched the restaurant surveillance video while Gowdy, his attorney, and the prosecutor looked on. Gowdy claimed he was acting in self-defense, but the judge was convinced Gowdy did not. The prosecutor offered Gowdy a plea deal. Gowdy told the judge he wanted to go to trial and argue self-defense. The judge told Gowdy he would not instruct the jury to consider self-defense. Gowdy met with his lawyer and then pleaded guilty to the amended charges in the plea deal. He then appealed his conviction, arguing the judge misstated the law on self-defense. Gowdy's new attorney told the Supreme Court the judge's errors tainted the whole process, and Gowdy's conviction should be overturned.
When have we ever said that a erroneous pretrial ruling is a basis to withdraw a guilty plea?
Well, Your Honor, I would say this is not the case of an erroneous pretrial ruling. It is true.
Isn't it essentially the same thing?
No, it's not. It's true that one of the errors the trial court made in this case was preemptively declaring that it would not give a self-defense instruction, but that's not the only error the trial court made in this case.
The Hamilton County Prosecutor's Office argued the trial judge did make mistakes, but was careful to ensure Gowdy pleaded guilty only after considering all of his options.
After the defendant consulted with counsel, there was a clear change of mind. And then the court, again, I believe, was very careful and whatever it said. And over and over again, repeatedly said that, so Gowdy, if you think we're coercing you, we're going to stop right now. We'll let a jury decide.
Gowdy's attorney insisted the trial court made a major error that should result in a new trial.
This is simply not a case of an erroneous pretrial ruling. This is a case in which Mr. Gowdy was forced to decide whether to plead guilty or not based on erroneous information provided by the trial court.
Chief Justice Sharon L. Kennedy announced the court will take the arguments under advisement and inform the parties of its decisions. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.